is marking up and reporting resolutions and postal naming bills. We have scheduled this markup so we can bring resolutions dealing with recent events to the floor quickly, and I thank the ranking member for working with us on these bills. I want to ask unanimous consent that these measures be considered in block and as read and open to amendment at any point. Is there any objection? Hearing none. The bills include House Res 299, introduced by Stephen Lynch. This measure expresses the sense of the House that public servants should be commended for their dedication and continued service to the nation during Public Service Recognition Week, May 4th through 10th, 09, and throughout the year. The second one is House Res 340, introduced by Representative Maurice Henchy. This measure expresses sympathy to the victims, families, and friends of the tragic act of violence at the American Civic Association in Binghamton, New York. Number 3, House Res 341, introduced by Representative Bobby Bright. This measure expresses heartfelt sympathy for the victims and families of the shootings in Geneva and Coffee counties in Alabama on March 10th, 2009. And House Res 342, introduced by Representative An Joseph Gao. This measure expresses support for the designation of May 2nd, 09 as Vietnamese Refugees Day. H.R. 1271, introduced by Representative Alcee Hastings. The measure designates a facility of the U.S. Postal Service in Pompano Beach, Florida, as the Elijah Pat Larkins Post Office Building. These are all worthy measures that meet our committee standards, and I urge their adoption. Does the ranking member have any comments?
Yes, I do. Thank you, Mr. Chairman. And I have reviewed each of these resolutions and postal namings and find them to meet the committee standard. Additionally, I want to thank the majority, the chairman and yourself, for working so quickly to bring these important resolutions to the floor, hopefully next week. And again, this is part of the new, just in time, we can get this done committee, and I yield back.
Thank you for that input. Do any other members wish to speak on these bills? Seeing none, I ask unanimous consent that the measures previously described be reported favorably by the committee without objection, so ordered. This concludes our business for today. The business meeting stands adjourned. Thank you.
We're going to start in about 5 minutes. Committee will come to order. Good morning. Buenos dias. Namaste. I want to thank the witnesses for being here. I'm Congressman Dennis Kucinich, Chairman of the Domestic Policy Subcommittee of Oversight and Government Reform. I'm here with the ranking member of the committee, Mr. Jordan of Ohio. And this committee today meets. The title of the hearing is the H-2B Guest Worker Program and Improving the Department of Labor's Enforcement of the Rights of Guest Workers. We have a panel of witnesses who is prepared to testify. Today's hearing is going to go into issues of enforcement and particularly with respect to labor rights for non-agricultural guest workers who come to the United States lawfully through the H-2B visa program. Now, without objection, the chair and ranking minority member will have 5 minutes to make opening statements, followed by opening statements not to exceed 3 minutes by any other member who seeks recognition. Without objection, members and witnesses may have 5 legislative days to submit a written statement or extraneous materials for the record. This hearing, the H-2B Guest Worker Program and Improving the Department of Labor's Enforcement of the Rights of Guest Workers, continues an investigation that this subcommittee began in 2007, evaluating the adequacy of labor law enforcement in New Orleans during the period following Hurricane Katrina. During the course of our investigation and the 2 hearings we held on labor law enforcement in New Orleans, the subcommittee discovered that H-2B visa holders who are non-agricultural guest workers have been exposed to egregious forms of abuse by sponsoring employers who brought them to the Gulf Coast to assist with the cleanup. These abuses include wage theft, poor living conditions, and threatening actions which amounted to human trafficking. Unfortunately, it is clear that the abuse of guest workers continues today in New Orleans and across the country. Today we will hear testimony from 3 guest workers, all of whom worked in different industries that the Department of Labor allows to hire foreign guest workers. Take, for example, the case of one of our witnesses, Abhi Karikathara Raju, who came to the United States from India to work for Signal International LLC at the Gulf Coast shipyard. Lured by false promises of permanent U.S. residency, Mr. Raju, along with hundreds of other Indian guest workers, paid tens of thousands of dollars to obtain this job with Signal, only to have their passports confiscated and find themselves forced into involuntary servitude, working for substandard wages and living in overcrowded, guarded labor camps. Unfortunately, these cases of worker abuse have gone largely unprosecuted by the federal cop on the workplace beat. The Department of Labor did virtually nothing to protect these workers. The explanation has 2 components. First, there are very limited legal protections in place for H-2B visa workers. Unlike H-2A guest workers, H-2B guest workers do not have legal access or do not have access to legal services, do not have protection from retaliation or payment of transportation to the United States. Second, the Department of Labor has utterly failed to enforce the rights of H-2B guest workers. The Department of Labor has interpreted the Immigration and Nationality Act and its implementing regulations to preclude Department of Labor authority to enforce the conditions of H-2B visa petitions in favor of Homeland Security's enforcement authority. At our hearing in June 2007, when we questioned former Department of Labor officials about why the abuse of guest workers in New Orleans had gone unchecked, we were told to ask the Department of Homeland Security. While that is debatable, the Department of Labor itself has acknowledged it still maintains authority to oversee wage and hour laws which apply to guest workers. Based on this subcommittee scrutiny, advocacy by labor groups, as well as recent reports by the GAO, however, it's clear that the Department of Labor's Wage and Hour Division has failed to do even that. There is a development in the law that requires mentioning as well. The previous administration passed a midnight regulation that weakens instead of strengthening protections for H-2B visa guest workers. The new regulation is also extremely harmful to U.S. workers because it makes it easier for employers to bring in guest workers for longer periods of time, reducing or increasing the risk that U.S. workers will be overlooked for a cheaper, less regulated labor source. Congressman Miller, Chairman of the Committee on Education and Labor, Congresswoman Zoe Lofgren, Chairman of the Immigration Subcommittee of Judiciary, have been working tirelessly on and will soon be introducing a new bill that will increase protections for both H-2B guest workers and U.S. workers. This subcommittee supports and applauds those efforts. The current weak regulatory framework for the H-2B visa program cannot be allowed to stand. The one silver lining in the previous administration's midnight regulation is the delegation of authority by DHS to the Department of Labor to establish an enforcement procedure to investigate compliance with H-2B requirements and remedy violations uncovered as a result by imposing fines or debarment. Many questions remain about the nature of that delegation and how DOL's oversight and enforcement of the H-2B visa will be carried out. But the acknowledgement by both Homeland Security and Labor that Labor has clear authority to enforce the rights of H-2B guest workers give this subcommittee hope that the Department of Labor will finally commit to investigating and prosecuting H-2B sponsoring employers who are abusing the program and exploiting workers. We had hoped to hear from Labor Secretary Hilda Solis today on the Department of Labor's plans to improve such oversight. But we understand that the Department is still in the policy development stage, and the Department asked that it be allowed to testify at a later date once the Senate has confirmed the Assistant Secretary for the Employment Standards Administration and an Administrator of the Wage and Hour Division. We're hopeful that the Department will consider the testimony presented in today's hearing as they draw conclusions about what needs to be done with the H-2B visa program. This subcommittee certainly intends to see that Secretary Solis's introductory remarks to the Department of Labor that there's a new sheriff in town will benefit the lives and working conditions of guest workers. Today, I hope we can better understand the problems faced by guest workers and how the Department of Labor in the past has failed them. We're lucky to have a very strong panel of labor advocates who can shed light on how to create a stronger Department of Labor that can fulfill its mission of protecting the rights of all workers. I want to thank you again for being here, thank my colleagues who are present, and now turn to the ranking member of this subcommittee, Mr. Jordan of Ohio. You may proceed.
Thank you, Mr. Chairman. I want to thank you for putting this hearing together and for the great working relationship I have with you, fellow Ohioan, and thank our panel, our first panel and our second panel as well. This hearing provides an excellent opportunity to discuss and debate the existing H-2B guest worker program and the newly delegated enforcement of H-2B violations to the Department of Labor. This is an important matter, and I look forward to having a productive discussion on the many issues surrounding the present H-2B visa program and their economic implications. We all agree that enforcement of the law and protection of guest workers is critical. Many organizations and individuals, including some that we will hear from later, have advocated for substantial reforms to the H-2B guest worker program. Indeed, some of these proposed reforms might be helpful, but let's also keep in mind today that implementing many of the suggested policy changes may require Congress to entirely overhaul the guest worker program. As a result, our discussion needs to also examine how reforming the current program will affect the economy and U.S. workers. Being a representative from Ohio, a state struggling with economic hardship and the housing crisis, this is an issue that hits close to home. In 1986, Congress passed the Immigration Reform and Control Act. The act contained major revisions of the temporary worker H-2 program. Specifically, it divided the H-2 program into two separate visa categories, the H-2A program for temporary agriculture workers, and the new H-2B was created for temporary non-agriculture workers. Today's hearing will focus on the existing H-2B program. On January 18, 2009, the Department of Homeland Security delegated its enforcement authority of H-2B violations to the Labor Department. I would like to emphasize that prior to this delegation, H-2B violations went largely unenforced by DHS. Without a doubt, the failure to enforce existing laws is unacceptable. Prior to January 18, 2009, Labor's enforcement of H-2B wages was limited to laws specifically delegated to the Department of Labor, such as the Fair Labor Standards Act. However, following the delegation of enforcement by DHS, the Department of Labor immediately promulgated regulations that would enforce the H-2B program. As it now stands, H-2B employer will have to make certain guarantees to the Department of Labor regarding their hiring of H-2B workers. Most relevant to today's hearing, it is important for this subcommittee to take into consideration that an H-2B employer must attest and demonstrate that qualified persons in the United States are not available and that the terms of employment will not adversely affect the wages and working conditions of the workers in the United States similarly employed. These employer attestation requirements for the H-2B application provide a foundation to prevent employer violations while at the same time encourage employers to use U.S. workers. Now that DHS has delegated to DOL, or Department of Labor Enforcement Authority, for the H-2B violations, the Department of Labor has supplemented U.S. worker protection with new mechanisms to ensure compliance with H-2B filing and attestation requirements, including penalties, debarment, supervised pre-filing recruitment, and post-adjudication audits. In short, the Department of Labor now has the authority and capability to enforce the H-2B violations. Unfortunately, the change in administration and the slow appointment process has left the Department of Labor with a limited management staff and no one who is capable of testifying on the implementation of the H-2B program is present today. No accurate assessment of the H-2B regulations can be made without a representative from the Department of Labor, but it appears that the Department of Labor has failed to implement any of the new H-2B regulations laid out above. I hope to eventually hear, as the Chairman indicated in his opening statement, the administration's perspective on the H-2B program before this subcommittee. In fact, I think the words the Chairman used were the Department of Labor has utterly failed in many of the things we're talking about today. The Department of Labor should be given a chance to enforce the regulations promulgated on January 18, 2009. To be sure, once the existing regulations are enforced, Congress and the Department of Labor will be in a better position to assess the H-2B visa program. However, before Congress and the Department of Labor can seriously consider future changes to the H-2B program, the broader economic implications of the guest worker program must be thoroughly examined and discussed. Thank you, Mr. Chairman, for holding this important hearing today. These issues not only affect our home state of Ohio, but also the entire United States, and I look forward to hearing from our witnesses.
I thank the gentleman. I just want to say that I appreciate the chance to work with you. And the one good thing about this Domestic Policy Subcommittee, as with all subcommittees of government oversight, is that, and this doesn't relate specifically to the Department of Labor, but to any government agency or department, that we generally get their cooperation, and that's nice. That has nothing to do with the fact that we have subpoena power, by the way. Mr. Foster, Chair recognizes you for 3 minutes.
Thank you, Mr. Chairman. While today's hearing will no doubt have wider implications on labor policy and the economy, this is also an opportunity to further understanding and address the administrative shortcomings within the Labor Department in this area. In previous hearing, the subcommittees investigated labor law enforcement and protection of guest workers by the Department of Labor in the aftermath of Hurricanes Katrina and Rita, and has uncovered cases of abuse by sponsoring employers during the Gulf Coast cleanup. Today, however, we may gain a clearer view of nationwide patterns of abuse and fraud within our guest worker programs and begin to devise rigorous reporting and accountability measures to ensure the Department of Labor acts swiftly and to uncover abuse and enforce existing labor laws. In a recent report, the GAO noted that the Labor Department's Wage and Hour Division, the body charged with administering laws like the Fair Labor Standards Act and the Migrant and Seasonal Agricultural Worker Protection Act, insufficiently responds to reports of abuse and fails to consistently enforce the terms of guest worker labor certifications, which designate wages and work schedules. Many of today's witnesses will correctly point out the vulnerability of guest workers who have no leverage to bargain for higher wages or better working conditions. The downward pressure on wages that results from this lack of enforcement is not only exploitative for the guest worker, but also means that jobs become increasingly undesirable for U.S. workers. I look forward to hearing from each of our witnesses on the ways the bureaucracy can be made more responsive and accountable, including any proposals for publicizing patterns of abuse and fraud. Thank you, and I yield back.
Thank you very much, Mr. Foster. Does Mr. Tierney have an opening statement?
No, I don't, Mr. Chairman, other than thank you for having this hearing, and as always, you're looking out for people's rights, and we appreciate that.
Thank you for being on the subcommittee. Ms. Watson, do you have an opening statement?
I do.
Chair recognizes a distinguished lady from California, Ambassador Watson.
I also want to thank the chairman for holding today's important hearing examining the state of H-2B non-agricultural guest worker visa program. I sincerely hope that today's proceedings will reveal the weaknesses associated with the program and the steps that can be taken to strengthen the rights and protections for H-2B visa holders. Previous hearings and investigations conducted by this subcommittee revealed serious abuse by sponsoring employers in the Gulf Coast during the cleanup after Hurricane Katrina. Unfortunately, these practices were not isolated incidents, but representative of similar abuses which occur across the country due to the uneven power dynamic between guest workers and their employers, and an ineffective system within the Department of Labor to regulate employers who violate labor laws. Due to the loophole in H-2B regulations and the assertion that enforcement of labor laws affecting these guest workers was outside the authority of the Department of Labor, this program has operated with essentially no enforcement mechanism or penalties for employers who violate their guest workers' rights. A new Department of Labor regulation on December 19, 2008, solidified the notion that enforcement authority was within the jurisdiction of the Department of Labor. But while this was a positive step, its practical application has proven to be unevenly flawed. According to a March 2009 report by the GAO, the Department of Labor's Wage and Hour Division processes for complaint intake, conciliation, and investigation are so ineffectual, they actually discourage workers from making complaints. Healthy immigration and labor policy needs to be based upon the premise of fair wages for honest work in a safe environment. Employers who rely upon temporary foreign workers must operate under this principle with the knowledge if they are in violation, they will be investigated and penalized by the Department of Labor. With the advent of a new administration and a new Secretary of Labor, this hearing occurs at an opportune moment to assess current practices and to reveal the actions needed to protect the rights of all guest workers. And I would like all of today's panelists, I would like to thank them for participating. And sharing your experiences will help us ensure future guest workers in the H-2B visa program are empowered with the proper rights and the necessary infrastructure to protect you. And with that, Mr. Chairman, I yield back the remainder of my time, and again, thank you.
I thank the gentlelady, and if there are no additional opening statements from members of the subcommittee will now receive testimony from the witnesses. I want to start by introducing our first panel. Mr. Abhi Karikatara Raju, did I pronounce that right? Okay. Is a former H-2B guest worker for Signal International, LLC. Mr. Raju is a structural welder from Kerala, India. He's a member of the Alliance of Guest Workers for Dignity. Mr. Miguel Angel Jovel Lopez is a former H-2B guest worker for Cumberland Environmental Resources. He came to the U.S. from El Salvador and works as a construction laborer. He is also a member of the Alliance of Guest Workers for Dignity. Mr. Daniel Castellanos Contreras is a former H-2B guest worker for Decatur Hotels, LLC. He came to the U.S. from Peru, where he is a licensed engineer and formerly owned a small business. He's an organizer and founding member of the Alliance of Guest Workers for Dignity. I want to thank you for appearing before this subcommittee today. Now, we also have two interpreters, and I would like the interpreters, if you would please identify yourself, your name, where you're from, and if the court stenographer can also take that information, and members of the committee can be aware of it. If you'd start with Mr. Raju's interpreter, your name. Could you please turn on the...
Okay. My name is Bincy Jacob. I work with the New Orleans Worker Center for Racial Justice.
And would you spell your last name?
Sure, it's Jacob.
Okay. Yes, sir.
My name is Jacob Horwitz. I also work with the New Orleans Worker Center for Racial Justice, and that's HORWITZ. Thanks for having us.
Okay. Now, it's the policy of this subcommittee to swear in all witnesses before they testify. Since we have individuals who are interpreting, we're going to ask that you be sworn as well. So I would ask that all witnesses please rise. And please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Okay, let the record reflect that each witness answered in the affirmative. I would ask the witnesses now to give a brief summary of their testimony and to try to keep this summary under 5 minutes in duration. Since we're working with interpreters, we may have to give a little bit of play to that, but just I want you to keep in mind that your written statement will be included in the hearing record. Thank you. Do you have any questions about that, by the way? Do you have any questions about this procedure? No? Okay. We're all set? Okay, let's proceed then with Mr. Raju.
Thank you.
And please speak into the mic as best you can, and the interpreter can go back and forth. Go ahead.
എൻ്റെ പേര് എബി കാരിക്കത്തറ രാജു എന്നാണ്.
My name is Ebi Karikatra Raju.
We're going to have to ask you to bring that mic a little bit
Okay.
closer to both of you and just you kind of move it back and forth. Go ahead.
ഞാൻ ഇന്ത്യയിൽ നിന്നും H-2B വിസയിൽ ഒരു ഗസ്റ്റ് വർക്കറായി ഈ രാജ്യത്ത് വന്നതാണ്.
I came to this country as a guest worker on an H-2B visa from India.
ഒരു ഗസ്റ്റ് വർക്കർ എന്ന നിലയിൽ എൻ്റെ ജീവിതത്തിൽ ഞാനിവിടെ വന്നതിന് ശേഷം അനുഭവിക്കേണ്ടി വന്നതും ഞാൻ കാണാനും കേൾക്കാനും ഇടയായ സംഭവങ്ങൾ നിങ്ങളുമായി ഷെയർ ചെയ്യാനായിട്ടാണ് ഞാൻ ഈ സമയത്ത് ഇവിടെ ഇരിക്കുന്നത്.
I'm here to share with you the experiences of what I saw and I heard and I felt in my life as a guest worker in this country.
കമ്പനിയുടെയും റിക്രൂട്ടേഴ്സിൻ്റെയും ലേബർ ട്രാഫിക്കിങ്ങിൻ്റെ ഫലമായി 2008 മാർച്ചിൽ ഞങ്ങൾ 200-ന് മുകളിൽ പേർ ക്യാമ്പിൽ നിന്നും ഓടി രക്ഷപ്പെട്ട് ഒരു ലോ സ്യൂട്ട് ഫയൽ ചെയ്തു.
In 2008, as a result of the company and the recruiters' labor trafficking, over 200 of us escaped the labor camps and found refuge.
സിഗ്നലും റിക്രൂട്ടേഴ്സും പല തെറ്റായ വാഗ്ദാനങ്ങളും നൽകി ഞങ്ങളിൽ നിന്നും $20,000 വരെ വാങ്ങി H-2Bയും പെർമനന്റ് റെസിഡൻസിയും പറഞ്ഞാണ് ഞങ്ങളെ ഇവിടെ കൊണ്ടുവന്നത്.
Signal and the recruiters lied to us and gave us false promises of H-2B visas with permanent resident visas and collected up to $20,000 from each of us.
അതെല്ലാം തെറ്റായിരുന്നു എന്ന് മാത്രമല്ല വളരെ മോശമായ ലിവിങ് കണ്ടീഷനിലും വർക്ക് കണ്ടീഷനിലും കഴിയേണ്ടി വന്നു ഞങ്ങൾക്ക്.
And not only that, when we came here, we had to live in very poor conditions and work under very poor conditions.
ഇതിനെതിരെ ശബ്ദമുയർത്തിയവരെ ഭീഷണിപ്പെടുത്തുകയും ബലമായി ഡീപ്പോർട്ട് ചെയ്യാൻ ശ്രമിക്കുകയും ഉണ്ടായി.
And for those of us who spoke up against it, they tried to forcefully deport and threaten them.
പ്രെയർ മീറ്റിങ്ങിന് വന്ന പാസ്റ്ററെ പോലും അവർ സെക്യൂരിറ്റി ഗാർഡിനെ ഉപയോഗിച്ച് ഗേറ്റിൽ തടഞ്ഞു വെച്ചു.
They used the security guards to hold back the pastor who came to help us to have a prayer meeting.
ഇതുകൊണ്ടാണ് ഞങ്ങൾ ഇവർക്കെതിരെ ശബ്ദമുയർത്തുകയും ഫയൽ സ്യൂട്ട് ചെയ്തതും.
And these are the reasons why we had to raise our voice and file a lawsuit.
നിർഭാഗ്യവശാൽ ഇതുവരെ ഒരു ഗവൺമെൻറ് ഏജൻസിയിൽ നിന്നും ഞങ്ങൾക്ക് ഒരു നീതി ലഭിക്കുകയുണ്ടായില്ല.
Unfortunately, we have yet to receive justice from any government agency.
അഡ്വക്കേറ്റുമാർ പറഞ്ഞു ഈ രാജ്യത്ത് ഞങ്ങളെ സംരക്ഷിക്കാൻ നിയമങ്ങളുണ്ടെന്ന്, പക്ഷേ ഇതുവരെ ഞങ്ങൾക്ക് ഒരുവിധ നീതി ലഭിക്കുകയുണ്ടായില്ല.
Advocates told us that there are laws in this country to protect workers like us, but we have not received any justice.
ഞങ്ങൾ മനസ്സിലാക്കുന്നു നിങ്ങൾ കോൺഗ്രസിൽ ഇരുന്നുകൊണ്ട് ഈ നിയമങ്ങൾ ഞങ്ങൾക്ക് വേണ്ടി നിർമ്മിക്കുന്നു.
We really believe that you in Congress created these laws to protect us.
പക്ഷേ സത്യത്തിൽ ഈ നിയമത്തിൻ്റെ ഒരു ഗുണവും ഞങ്ങൾക്ക് ലഭിക്കുന്നില്ല എന്നുള്ളതാണ്.
But the truth is we haven't received any of the benefits of these laws.
ഞാൻ ഈ രാജ്യത്ത് വന്നിട്ട് ഒരിക്കൽ പോലും കേട്ടിരുന്നില്ല ഡിപ്പാർട്ട്മെൻറ്റ് ഓഫ് ലേബറിനെ കുറിച്ച്.
Since coming to this country, I had never heard of the Department of Labor.
ഈ ഡിപ്പാർട്ട്മെൻറ്റിൽ നിന്ന് ഒരു വ്യക്തിയും ഞങ്ങൾ താമസിച്ചിരുന്ന ക്യാമ്പിൽ വരികയോ ഇൻസ്പെക്ഷൻ നടത്തുകയോ ചെയ്തിട്ടില്ല.
Not a single person from this department came to where we lived or to our work site and conducted an inspection.
ക്യാമ്പിൻ്റെ മോശമായ അവസ്ഥയെപ്പറ്റി പരാതിപ്പെട്ടപ്പോൾ കമ്പനി പറഞ്ഞു ഈ ക്യാമ്പ് US ലോസ് പ്രകാരമുള്ളതാണെന്ന്.
When we complained about the poor conditions in the camp, the company told us this camp is under the US laws.
ശബ്ദമുയർത്തിയ വർക്കേഴ്സിനെ ആംഡ് സെക്യൂരിറ്റി ഗാർഡ്സിനെ ഉപയോഗിച്ച് ലോക്ക് ചെയ്യുകയും ബലമായി ഡീപ്പോർട്ട് ചെയ്യാനും ശ്രമിച്ച കമ്പനി പറഞ്ഞത് ഇമിഗ്രേഷൻ്റെ നിർദ്ദേശപ്രകാരമാണ് ഇതെന്നാണ്.
When the company used armed guards to lock up workers and tried to forcibly deport them, the company told us that we're doing this because immigration told us.
ഞങ്ങൾ ലോസ്യൂട്ട് ചെയ്തപ്പോൾ ഡിപ്പാർട്ട്മെൻറ്റ് ഓഫ് ജസ്റ്റിസ് ഡിപ്പാർട്ട്മെൻറ്റ് ഓഫ് ലേബറുമായി ചേർന്ന് പ്രവർത്തിക്കുന്നതിന് പകരം ഇമിഗ്രേഷനുമായി വർക്ക് ചെയ്തു. അതിനുശേഷം ഇമിഗ്രേഷൻ ഞങ്ങളുടെ മേൽ സർവൈലൻസ് നടത്തുകയുണ്ടായി.
When we filed a lawsuit, instead of the Department of Justice working with the Department of Labor to help, Department of Justice worked with immigration, and after that we had surveillance over us.
ഞങ്ങൾ ഇപ്പോഴും ഗവൺമെൻറ് ഏജൻസികളുടെ ഒരു ഡിസിഷന് വേണ്ടി കാത്തിരിക്കുകയാണ്.
And we are still awaiting the decision of a government agency.
ഒരു ഫോറിൻ വർക്കർ ഈ രാജ്യത്ത് വന്നാൽ ഡിപ്പാർട്ട്മെൻറ്റ് ഓഫ് ലേബർ നേരിട്ട് വന്ന് ഇൻസ്പെക്ഷൻ നടത്തേണ്ടതാണ്.
If a foreign worker comes to this country, the Department of Labor should directly go and do an inspection.
അവരുടെ ലിവിങ് കണ്ടീഷനും അവരുടെ വർക്ക് കണ്ടീഷനും ബെറ്റർ ആണെന്ന് അവർ ജോലി ആരംഭിക്കുന്നതിന് മുമ്പ് തന്നെ ഉറപ്പുവരുത്തേണ്ടതാണ്.
Before the work even starts, they have to ensure that the living conditions and working conditions are good enough for them to stay there.
ഒരു ഗസ്റ്റ് വർക്കർ മുന്നോട്ട് വന്ന് അയാൾക്ക് അനുഭവിക്കേണ്ടി വരുന്ന കാര്യങ്ങളെപ്പറ്റി റിപ്പോർട്ട് ചെയ്യുമ്പോൾ ഡിപ്പാർട്ട്മെൻറ്റ് ഓഫ് ലേബർ മറ്റൊരു ഏജൻസികളുമായി ചേർന്ന് ഇൻവെസ്റ്റിഗേഷൻ നടത്തി വേണ്ട നടപടികൾ സ്വീകരിക്കേണ്ടതാണ്.
When a worker comes forward and makes a complaint about what they experience, the Department of Labor should work with other agencies to see what the investigation should be and to move forward correctly.
ഇങ്ങനെ മുന്നോട്ട് വരുന്ന വർക്കറെ സംരക്ഷിക്കുവാൻ വേണ്ടി അവർ മറ്റൊരു എംപ്ലോയറുടെ കീഴിൽ ഒരു ജോലിക്ക് അയാളെ സഹായിക്കുകയും ചെയ്ത് അയാളെ സംരക്ഷിക്കേണ്ട സഹായം കൂടി ചെയ്യേണ്ടതാണ്.
And not only that, for workers who come forward, the Department of Labor can support them in finding another employer so that they can be safe in this country.
ഇതിലൂടെ മാത്രമേ ഡിപ്പാർട്ട്മെൻറ്റ് ഓഫ് ലേബറിന് ഒരു ട്രാഫിക്കിംഗ് എന്ന ഈ സിസ്റ്റം ഈ രാജ്യത്ത് തടയാൻ സാധിക്കുള്ളൂ എന്ന് ഞാൻ വിശ്വസിക്കുന്നു.
And I truly believe that it's only with these steps that the Department of Labor can help stop trafficking in this country.
Thank you.
Dhanyavad. Mr. Lopez, you may proceed.
Bueno, mi nombre es Miguel Ángel, soy de El Salvador y vengo a exponer mi experiencia, mi testimonio, lo que he estado viviendo hasta ahorita en el país de los Estados Unidos.
My name is Miguel Ángel. I'm from El Salvador, and I've come here to share and expose my testimony, what I've been living and experiencing in the United States.
Yo vine con una visa H-2B de El Salvador, lo cual para obtener esta visa yo tuve que endeudarme en mi país como con $4,000 y hasta ahorita no he salido todavía de mi deuda.
In order for me to come to this country from El Salvador on an H-2B visa, I had to indebt myself and my family $4,000, and I still haven't gotten out of this debt.
Soy padre de familia, tengo una hija, una esposa, 4 hermanos que dependen de mí y hasta ahorita no he satisfecho ninguno de los sueños que traía hacia el país de los Estados Unidos.
I'm the head of my household. I have a young daughter, a wife, and 4 younger brothers that depend on me. And since I've come here, I haven't satisfied even one of my hopes of coming to the United States.
Me prometieron muchas cosas en mi país. Luego cuando llego acá, las promesas eran completamente falsas. Yo venía a trabajar en recolección de escombros y me mandaron a trabajar en el peligroso trabajo de asbestos.
I was promised many things in my home country, but when I arrived, I realized that they were completely false. Instead of working in demolition, which is what I was promised, I was put to work doing asbestos cleanup.
La compañía nos rentaba a otras compañías para poder trabajar en hospitales, trabajos del Estado, en campamentos de bases militares, y lo que nos pagaban no era lo que la hora lo que valía la hora que tenía que pagar en el trabajo que nosotros hacíamos.
the company that I was brought to work for rented us out to other contractors, including on government work sites, military bases, hospitals, and universities, and they paid us a small percentage of what the work was really worth.
Viendo yo y mis compañeros que fuimos despedidos por la compañía Cumberland, el 13 de febrero nos declaramos en huelga y tuvimos que poner una queja al Departamento de Labor.
Seeing all these problems, my coworkers and I began to organize. We went on strike and were fired, and then we put a complaint in with the Department of Labor in February.
Mis compañeros y yo pedíamos una reunión con el patrón y para hablar sobre el trabajo y de los requisitos que tiene el contrato, y el patrón nunca aceptó la reunión con nosotros.
We only wanted to have a meeting with our boss to talk about the requirements of the contract and to talk about but our boss never accepted that meeting with us.
Tenemos ya 2 meses de ver puesto reportar la compañía al Departamento de Labor, y hasta ahorita no hemos recibido ninguna respuesta del Departamento de Labor. Queremos que el Departamento de Labor ponga manos a esta situación que nosotros hemos vivido desde que regresamos acá al país.
So it's been 2 months since we've reported this abuse to the Department of Labor, and still we've heard no response at all. And we want the Department of Labor to really take this case seriously and investigate.
Yo como representante de este grupo pido al Departamento de Labor que investigue a estas compañías a que vea que sí cumplan con los contratos y que las personas que traen a trabajar sean muy tratadas a como dice el contrato.
As a representative of this group of the Alianza, I ask that the Department of Labor investigate these companies, that they make sure that people who are coming to these companies are treated in the way that they're supposed to be treated under the law.
También pido una protección a todos los trabajadores que reportan a estas compañías para que no se sientan con miedo de poder reportar a cualquier compañía en caso de que ellos estén en una protesta de derechos.
I also ask that the Department of Labor offer immigration protection for workers who report companies so that they're not afraid to come forward if they're in a situation where their rights are being taken advantage of.
Y que el Departamento de Labor no se tarde en dar una respuesta, porque lo que está pasando con nosotros hasta ahorita ya 2 meses y no hemos recibido lo que es nada.
And we ask for ourselves and everyone else that the Department of Labor doesn't take so long to give a response, because we cannot wait.
Gracias por darme la oportunidad de exponer mi testimonio. Espero que se haga justicia y que exijan al Departamento de Labor poner manos a los asuntos migratorios y a los de trabajo de visa H-2B. Gracias.
So thank you for the opportunity to give my testimony. I hope that this results in justice, and we demand that the Department of Labor really takes this case seriously and investigates it so that there's justice for us and for all workers. Thank you.
Gracias, señor López. Señor Castellanos Contreras.
Buenos días. Soy Daniel Castellanos del Perú y vengo en representación de muchos trabajadores huéspedes en los cuales representa la Alianza.
Good morning. My name is Daniel Castellanos. I'm from Peru, and I come here representing many guest workers that are members of the Alianza.
$4,000. Eso es lo que pagué por venir a los Estados Unidos y dejar a mi familia sumamente endeudada.
$4,000. That's what I paid to come to the United States, leaving my family extremely in debt.
En el Perú, eso es lo que yo ahorraría trabajando duro en un año, y solo los ricos lo poseen.
In Peru, $4,000 is what I would make during a whole year of hard work, and an amount of money that only rich people have on hand.
Como organizador de la Alianza, he conocido a cientos de trabajadores, todos ellos oprimidos por la gran deuda adquirida.
As an organizer with the Alliance, I've known hundreds and hundreds of workers, all of whom have suffered and been oppressed by the huge debt that they have.
todo para venir a trabajar acá a los Estados Unidos.
all in order to come and work in this country, the United States.
Trabajadores que vendieron sus cosas e hipotecaron sus casas tratando de alcanzar sus sueños.
Workers that sold their houses, mortgaged land, and sold personal family items in order to come.
La mayoría de ellos siguen endeudados porque el tiempo de sus visas es demasiado corta y tienen que pagar costosas extensiones para seguir legales.
The majority of guest workers continue to be in debt because their visa terms are very short and they have to pay for very expensive extensions which trap them in this cycle of debt.
Es por eso que la deuda toma mucha importancia en la relación patrón-empleado.
For this reason, the debt is so important in the relation between the boss and the worker.
Porque con las regulaciones existentes es una clara violación a la ley de salario mínimo.
The current law, with the current regulations, the way debt plays out is a clear violation of the minimum wage.
Y además porque la deuda es lo que mantiene callados a los trabajadores.
Also, the debt is what keeps workers silent.
Porque si tú protestas, puedes ser despedido, deportado y nunca llegar a pagar tus deudas.
Because if you protest, you could be fired, deported, and never be able to pay that money back.
Por eso creemos que el Departamento de Labor debe de clarificar las reglas de los trabajadores huéspedes.
So we believe that the Department of Labor should really take a clear stance on this, on the law around H-2B workers.
Publicando su posición sobre el costo de venir de los trabajadores es una obligación del patrón por ser de su beneficio.
And publish the position that the fees and the money that workers pay to come to this country are the responsibility and are for the benefit of bosses that bring them to this country.
Y debe de pagar esto a los trabajadores en los primeros 15 días de trabajo.
And that they should reimburse this money to workers during the first 15 days of their employment.
También el Departamento de Labor debería tomar acciones más fuertes para enforzar esta ley.
Also, the Department of Labor should take much stronger actions in order to enforce this law.
Para así acabar con la servidumbre por deuda que vivimos día a día.
So that they can fully eliminate the debt servitude that we live daily.
Y también debería priorizar la protección migratoria de los trabajadores huéspedes que tengan disputas laborales con sus patrones.
Department of Labor should also prioritize the protection, immigration protection of workers that are in labor disputes with their employers.
Porque al no tener protección somos completamente vulnerables a las represalias de los patrones.
Because without having protection, we're completely vulnerable to retaliation by employers.
Nosotros, la Alianza de Trabajadores, creemos que somos los expertos en la visa H-2B.
We of the Alliance of Guest Workers for Dignity, we believe that we're the experts in the H-2B visa.
Porque lo vivimos a diario.
Because we live the experience daily.
Es por eso que creemos que debemos ser consultados para las mejoras de las reglas.
And so we demand that we be consulted when there's improvements to the law.
Sabemos que hay muchos intereses creados por empresas para ampliar el número de visas.
We know that there's many interests by companies to expand the number of visas.
Pero si no cambian las regulaciones y son más humanas a favor de los empleados, esto va a seguir siendo, va a ir de peor a mucho peor.
But if the laws don't change so that the workers can come with more human conditions, then this is going to just go from bad to worse.
Muchas gracias.
Thank you very much.
I want to thank the witnesses. We are now going to proceed to questions from the committee. I just would like staff to take note of this matter. You know, there are a number of constitutional questions that are being raised by this testimony, including, I think, one that could present an unusual 13th Amendment case, which amendment prohibits slavery and involuntary servitude. Because there is a condition that we're talking about here that really reflects being coerced into a form of involuntary servitude. And I'd like staff to take note of that as a possible course of action that this committee may want to pursue. I'd like to begin my questions with Mr. Raju. I understand that the Department of Labor failed to investigate even the most basic wage violation claims. Has the Department of Labor, to your knowledge, done anything to prosecute wage claims since the filing of your lawsuit?
ഡിപ്പാർട്ട്മെൻറ്റ് ഓഫ് ലേബർ ഞങ്ങളുടെ കാര്യത്തിൽ ഒരു കാര്യങ്ങൾക്കും ഇടപെട്ടിട്ടില്ല എന്ന് മാത്രമല്ല അവർ ഞങ്ങളുടെ ക്യാമ്പിൽ വരികയോ ഞങ്ങളുടെ കാര്യങ്ങളിലൊന്നും ഇടപെടുകയോ ചെയ്തിട്ടില്ല ഇതുവരെയും.
From even coming to the camp in the beginning until this day, I don't believe the Department of Labor has been involved in any part of our...
No action whatsoever that you're aware of?
ഒന്നും തന്നെ ചെയ്തിട്ടില്ല അവർ.
I'm not aware of anything that they've done yet.
Okay. Staff also is going to have to take note of that testimony. And I want to assure you, Mr. Raju, and your fellow plaintiffs that this subcommittee is going to continue to advocate that the Department of Labor and the Department of Justice adequately investigate these allegations of trafficking guest workers. Now, with respect to Senor Lopez, I'm going to be instructing my staff to contact the Department of Labor and inquire about the status of the complaint that you made in February to the Office of Inspector General regarding the abuse that you received by your H-2B employer. It may take longer than we'd all like for this new administration to make changes, but we're going to hold them to their promise to protect workers' rights. What is the single most important protection you feel would help assure guest workers do not experience the difficulties that you've had? What kind of protection do you think would be necessary?
Bueno, que no pertenecer a un solo patrón en cuanto a lo que es la visa H-2B, en mi mente está de que mi visa solo pertenecía a un solo patrón y yo no puedo trabajar en otra compañía. Lo que quiero es tener la libertad de poder trabajar en diferentes compañías, no pertenecer a un solo patrón.
Yeah, that would be the fact that I belong to one boss, and the change would be that we would have the freedom to work for other companies, not just the boss that brought us here.
Thank you very much. To Mr. Castellanos Contreras, as an organizer for Alliance of Guest Workers for Dignity, have you ever met with the Department of Labor about improving its outreach and enforcement of the rights of guest workers?
Como organizador de la Alianza hemos tenido muchas veces hemos ido al Departamento de Labor a tratar de llevar casos de otros grupos de personas, de otros trabajadores en diferentes estados.
As an organizer, we've gone to the Department of Labor many times trying to bring cases to them in different states.
Pero ellos siempre nos rechazan los pedidos que le hacemos diciendo que no les compete.
But they always deny taking action on these cases, saying that it's not their responsibility or jurisdiction.
Que es una responsabilidad del Departamento de Seguridad del Estado, porque nosotros no somos nacionales, somos inmigrantes.
They've told us that it's the responsibility of the State Department because we're immigrants, not nationals.
Pero leyendo la ley me he dado cuenta que nosotros que venimos con visas temporales de trabajo, tenemos los mismos derechos que un trabajador americano en el tiempo que estamos legales acá.
Even though reading the law, I know that as temporary workers, we have the same labor rights as any American.
And I thank you. I want to ask one final question, and that is, did the Department of Labor ever investigate charges that Decatur violated the Fair Labor Standards Act by retaliating against you?
No, ellos no
Did
investigaron.
you have any contact with the Department of Labor about that case?
Tuvimos algún acercamiento en un tiempo atrás, pero ellos en lo absoluto respondieron.
We did have some contact, but the Department of Labor never
Nothing was done, nothing.
did anything.
Nguna, nothing.
No.
Okay, thank you for your testimony. We're going to now move to questions from the ranking member, Mr. Jordan. You may proceed.
Thank you, Mr. Chairman. I want to thank all of you for your testimony. Let me just ask a couple basics first. How long have each of you been in the United States?
Bueno, nosotros como política de la Alianza hemos sido invitados acá a tratar el tema de los cambios de las reglas de la visa, y no creemos, como política de Alianza, creemos que eso no nos compete, no es.
You know, we've been invited to discuss improvements to the laws of the H-2B program, and as a policy of the Alianza, we don't really think that's an appropriate question.
Okay.
How long he's been in this country?
No sé.
Well, let me ask you this. Have you or would you reapply for the H-2B visa?
Bueno, yo no puedo decir de la experiencia de lo que pasó a otra persona. Bueno, en el caso yo como organizador he visto mucho de la gente que aplica muchas veces para poderse quedar acá.
As an organizer, I have seen guest workers that reapply many times to come and work here.
Porque en el corto tiempo que le dan de visa no tienen la capacidad para recuperar el dinero que gastaron para poder venir a los Estados Unidos.
Because in the very short time that they're given the visa for, they don't have the ability to recuperate the money that they paid to come.
Y esto crea un círculo vicioso en el cual hay muy pocas personas que ganan dinero por esto, pero los trabajadores no ganan nada en lo absoluto.
And so it creates a vicious circle where people are forced to continue to pay to come back to the country.
Any of the witnesses on this panel, have any of you reapplied, or would you consider reapplying based on the experience you've had, the experience you've testified to?
Bueno, yo creo que eso claro, eso básicamente no está, es una política de alianza no contestar ese tipo de preguntas. No lo vemos pertinente.